Okay, everyone. All right. So thank you for joining us. Thank you for dealing with my technology problems. This is the legal and financial basics for really for everybody, but we focus specifically on people who have some sort of major neurocognitive disorder, meaning either you or your loved one or somebody that you're caring for has some sort of issue that's relating to their cognition. And the reason why we do this in particular for cognitive decline is that we want to catch it early. We want you to know what to do in advance, how to plan for it, what happens if you haven't planned for it, and then what are the financial options out there since it is such a long-term disease. This disease does put a demand on families that most other diseases don't. So this is me. I'm a certified elder law attorney. Most people don't know what that means. I don't sue nursing homes, so don't call me for that. What we do is we're like estate planners on steroids, meaning that we do the basic estate planning, but we focus more on life planning rather than your death planning. Your death and legacy planning is a side effect, but we want to focus on what happens while you're alive first. So what you're going to learn today is advanced care planning basics, right? What do we need to know? What are the key legal documents that you're going to need to have in your plan? What are the strategies for financing the long-term care? What is out there? What are the next steps? Any additional resources? And then how Alzheimer's San Diego and you can work together. So advanced care planning basics. What does that mean, right? Um, when you turned 18, that was the day you were supposed to start thinking about this. So you may be watching this because you're caring for a loved one. You have a spouse, a parent, a neighbor, some person in your life that you're caring for. But you need to start thinking about it for yourself too. So advanced care planning really means making decisions about the care that you would want to receive if you become unable to speak for yourself. This could be a car accident, have a traumatic brain injury, you could have a stroke. It's not an age related issue. And I think a lot of people think they have time, but I have clients who are in their 30s and 40s that have had strokes. I have a horrible story of a recent person in their 20s that was on a head-on collision and had a traumatic brain injury. People get hit while they're riding their bikes, things like that. So you want to be able to think about this throughout your life and to start planning now. And because you want to make that any future decisions are based on your personal values and preferences. I like to explain the story about the sister who wanted her sister to be her healthcare agent. And unfortunately, her religious beliefs would not coincide with the healthcare choices she had decided on. And so I tried to explain that you can't have that person be your decision maker because they just, for moral reasons, can't make the decisions you wanted. And then what discussion and legal financial planning and communication do we need to do in order to make that plan become implemented? So advanced care planning is about planning for the what ifs, that may occur. It doesn't have to happen. And I like to think of this as reverse jinxing yourself, right? If you plan for it, it won't happen. But it's in what circumstances would I want something to happen? So it's bigger than who's going to make my decision. It's going to be what decisions do they make? So why do we care about planning? Why don't we just wait for the crisis? And I want you to think about the the options that you have, right? Options that you have in your life are, well, they're limitless until a crisis happens, and then your box gets really, really small. Number one, why? It reduces the need to make critical decisions during your crisis. In a crisis, I don't care how smart you are, I don't care who you are not able to think clearly. And so if you have already thought these things out in advance, you are going to be able to implement the plan rather than have to create a plan when your brain is just not capable because of the trauma that's happening at that moment. We can also ensure that decisions reflect your personal values and preferences. Everybody is different and nobody is more right than others. So we need to make sure that your plan reflects what you want. We also need to preserve eligibility for public benefits. This is a very personal line for me because I recommended, while I didn't live in the state, my parents go to a attorney to get their documents put together, and they didn't go to the one I recommended. They went to somebody else because of cost. And unfortunately, when my father had a health event, their documents did not have what I needed in order to qualify him for veterans benefits. And that was really upsetting to me in the hospital when I couldn't do anything. And I just told my mother, you better hope he wakes up. And luckily he did, but it was one of those situations where we want to make sure the right planning is in place so that we're able to access all the right benefits. And then always, we want to help families avoid formal probate. Probate is a very lengthy and expensive procedure in California, but it became much more important avoiding probate on January 1st of 2024. That was the day, and we're going to get into it, that the rules for Medi-Cal changed, which means that if you go to probate, and now everybody is qualified for Medi-Cal in some way or another, whether you're receiving it now or not, but the likelihood of somebody receiving it gets higher and higher now. And Medi-Cal does have a right to recover from your estate. We're going to walk through all this, but I want you really to focus on why probate became such a negative impact on families, because Medi-Cal can only now recover from your probate estate. So if we can pre-plan to avoid your probate, then we're going to be in a much better position. Okay, so what are some key concepts that we're going to talk about today? So estate planning, what it is, right? What is the administration? What's the protection and the distribution of assets in a manner consistent with the goals of the owner of the estate? That's all it really is. It's the documents that confer who does what and where everything goes. Benefits planning, the determination of eligibility for public benefits. So what kind of planning can we prevent the depletion of assets, right? The public benefit system in America is created to prevent impoverishment of spouses, as well as to preserve some sort of wealth transfer to keep people out of poverty. That is the purpose of it, because they don't want an entire generations of people on benefits. So you'll see that there's all these exceptions and these, why is the home exempt and why are certain things? And it is to prevent poverty because of some sort of catastrophic event. Special needs planning. So protective planning for individuals with developmental disabilities and any other type of disabled person who needs their assets protected to ensure that they can have all access to public benefits. It's important for capacity. We're talking about mostly focusing on people with a neurocognitive disorder, right? And so the capacity is the capability or fitness to perform an action or enter into a legal agreement. It's basically an ability to comprehend the nature and consequences of one's actions. I like people to think of capacity as it's very fluid, right? Probate Code 810 in California, we are presumed to have capacity. Probate Code 811 says a diagnosis alone is insufficient to deem you to lack capacity. So I have a lot of people call my office saying, well, mom's been diagnosed with Alzheimer's, I have to take over. Well, that's not true. Moms get dementia, I have to take over. No, the idea is that you may need to support this person, but you don't get to take over. If somebody is capable of making one decision but not another, they still have capacity for that one decision they can make, right? So capacity is, do you understand the nature and consequences of the specific decision you're making? Because if you do, you retain the capacity to make that decision. And I kind of give the example of, I may not be able to manage a $20 million business, but I still know that I have an electric bill that needs to get paid. Those are two different things. It's different levels of capacity. And then a conservatorship. I always make the joke that I can't believe I get to thank Britney Spears 3 times a week, but because of Britney Spears, most people know what a conservatorship is now. And a conservatorship, and other states call them guardianship, so that's why that's there. But it's for anybody over 18 who does not have any legal planning documents in their possession. Basically, conservatorship is estate planning for you while you're alive if you didn't do any. So it's a court proceeding in which a judge decides who's going to be manage your money and make your medical decisions. Okay, so I just went through a whole lot right there. So before I continue on, I want to make sure there's no questions on those issues. And it looks like I don't see any open questions.
Yeah, Kim, thanks for checking on that. I'm looking at our Q&A section. We have not received any questions just yet. So again, for everybody who's attending, if you do have any questions as we go, feel free to put them into that Zoom Q&A feature there. And I will keep an eye on those. And when we reach these section breaks, I'll make sure that we get a chance to have Kim answer those. Kim, great start to this, by the way. Very helpful with all of this. And go ahead and continue.
Thank you. All right, so what are these key legal documents? What do we need in our arsenal? right? The basic documents. So you can have just a will, which is your last will and testament. The idea of just having a will is you need to be mindful of that. A will is what can end you up in probate. It's a great device that will say where everything goes. But if you have assets that require a signature to transfer, then you will end up in probate. So probate really is just a judge deciding who can sign your name when you're dead. So for example, if you have a home, and how do you sell it or how do you transfer it? You sign a deed. What can't you do when you're dead? Sign a deed. So if you have a will that says my home goes to Susie, then the only way for that house to get to Susie is for somebody to sign your name, but you're dead. So now you need a judge to authorize somebody to sign it. That's what probate is. So we don't want that. If you have a will, and if you have real estate or any other assets that require a signature to transfer, like a large bank account, right? You need a signature to transfer that and to close it. You'll need a trust. And the reason why you need a trust is a revocable living trust, meaning it's revocable during lifetime. A trust, a lot of people have a misunderstanding of what a trust is. They think it's for rich people. They think it's for, I'm going to give my assets away. I'm not going to have control. That is not what it is. A trust is a manual for your life. Who is going to manage your life and your assets under different circumstances of your life? There are three stages in every trust that's defined. Number one, when you are alive and well, who is going to be the manager of your life and who is going to be the manager of your assets? If you put assets into a trust, meaning you say, I, Kimberly McGhee, give Kimberly McGhee, trustee of the McGhee Family Trust, I just gave my assets to me as a trustee of my own trust. So I'm alive and well. I manage my trust. It's my money. I manage it for myself, right? So I'm alive and well. I am the manager and the owner. If I become incapacitated, I've decided who's going to manage my money for me. So it's still mine. It's just I have a new manager in place. But then let's say I get hit by the bus and instead of a traumatic brain injury, I am dead. Then my manager that I've decided who can sign my name when I'm either incapacitated or dead, they are now going to give the assets to my kids. So until you're dead, that money remains yours. So that's it's some sort of mistaken belief of what a trust is. And I want to undo that. And if you have a revocable living trust, right, it's amendable, revocable during your lifetime. It becomes irrevocable when you die because you can't change it anymore because you're dead. But you will need the accompanying pour over will. And that's the will that you get with the trust that says, if I die and I have something out of my trust, I want my will to catch it and pour it into my trust. That's what the name is. I didn't make it up. It's just what they call it. But it basically is a will that says instead of leaving everything to Susie or to Johnny, it says I leave everything to my trust. Most importantly, so part of it is, the will and the trust are very important, focusing on your death. The trust is important because it focuses on your life as well, but you can do those through powers of attorney. So at a minimum, an absolute minimum, every single person that's watching this who is over 18 must have a durable power of attorney for asset management and a durable power of attorney for healthcare, which we call the Advanced Healthcare Directive in California. And so the durable power of attorney, and I feel like, nope, okay. I think it's on the other slide, but it's not. So I'm going to switch over here. The durable power of attorney for asset management is just the document that says who is going to manage my personal affairs. So, for example, if you do have a trust, you have your home in the trust, you've got investments in the trust, but I have a 401k and I have a IRA and I have an electric bill and a water bill and a cable bill and a phone bill. All of those things are in my personal name. So my power of attorney for asset management is the person that's going to step into my shoes when I can't, right? Because two doctors have deemed me to lack capacity. I do not hand over power to anybody while I'm alive and well. Unless a lot of times spouses will do immediate to each other, but most of the time it is a springing, meaning you don't get to act for me unless I can't act for myself. That is a power of attorney for asset management. Everybody needs that. I love to give the example of a lot of my friends' kids are turning 18. And so for their birthdays, I give them powers of attorney. And they go, Mrs. McGhee, we don't have anything. Why do we need it? And I laugh because I say, okay, well, what happens if you get in a car accident? Who's going to talk to your doctor? Well, my mom. And I say, well, no, your mom can't. And so we'll talk about that on the next slide. Why? But they're like, oh, I thought my mom can't. So we need to do a durable power of attorney for healthcare. They also say, well, I don't have any assets, so why do I need the durable power of attorney for asset management? And then I always make the joke that we have a phone, right? And they say, yes. I'm like, if nobody can pay the bill, you're going to lose everything, your iCloud, and people freak out and they're like, I'll sign anything. So it's the idea that, even being an 18-year-old that doesn't have anything in their mind, they still need it. So the Advanced Healthcare Directive, the living will, that's what we used to call the living will. I think in New York, it's still called the healthcare proxy. But pretty much the Advanced Healthcare Directive is the document which defines your wishes, but it also appoints a power of attorney for healthcare. And so the reason why that's important is it defines how you want to be treated, like under what circumstances, and what does it look like for you. And you can make it as detailed as you want. And I really love it detailed because it takes the burden off of the decision maker. But the most important part of that is the waiver of the Health Insurance Portability and Accountability Act. It's the HIPAA waiver, right? Before COVID, it wasn't as big of a deal. Most doctors, most physicians, most hospital organizations did not really comply with HIPAA. It wasn't until COVID that they really realized, oh my goodness, we've been violating these health concerns and giving confidential information away. So that became an issue, and we learned that pretty strongly. So what was happening at that time is people were calling my office saying, my spouse of 64 years is in the hospital and I don't know if they're alive or dead, because they, over the phone, can't talk to anybody. People feel like, oh, it's not a big deal. Because when you're in the hospital crying next to the bed, the hospital staff gives pity on you and they're going to give you information. But legally, they weren't allowed to. So we also have things like DNRs, do not resuscitate orders, and PULSE, and I call it the pink paper. So it's the physician orders for life-sustaining treatment, but it's the pink paper. If you want to talk to your doctor about it, they know. Those are not documents that attorneys do. Those are documents that the physician does with you. And it's an order, meaning that if you say, do not resuscitate me, and you have a heart attack, and then paramedics come, and there's a pink paper standing above you that says, do not resuscitate, the paramedics will watch you die. If you have an advanced healthcare directive that the agent is saying, no, they don't want any resuscitation, the paramedics will continue resuscitating you. So one is a physician's order, one is your wishes. Those are two different things. So let's say we have them, right? I have a lot of clients that are like, well, 20 years ago, we put these documents in place and we've never looked at them. They're on a shelf and they've never seen them again. It's important that we update them. You don't have to update them annually. I mean, I guess as you age, the closer you get to the end of your life, you want to look at it more because you are statistically getting closer. But it's important to review them regularly. We tell people every 5 years, unless there is a major life event. And by major life event, I mean, it could be with friends, something happened with your best friend and their family, and you saw, oh my goodness, that changes things. You've picked agents. Like I like to give the example. I always feel bad if my brother ever watches this, but one of my brothers is a physician. He was my healthcare agent, and my father had a health event, and I didn't necessarily enjoy how he did it, how he handled it. So I changed him. And the next day, because a life event happened, and I disagreed with how he handled it. So I wouldn't want him doing it for me, not out of lack of love or any type of affection. It just wasn't how I would have wanted it handled. And so those are life events that make you want to rethink how things are going. I kind of tell people, like with kids, it's a really good one because sometimes they just, I don't know what attorneys were out there thinking this, but they just picked a firstborn son and, or the caregiving daughter, and it's just automatic. But that's not true. It's a job. You're picking somebody for a job. So who would you hire for that job? And so a life event could happen and you see a child and you're like, ooh, that's not a good thing. Or let's say they go through a divorce or they have a major crisis in their own personal life. You see how if they rose to the occasion, they fall from it. There's a lot of a lot of factors that go into it. And sometimes we need to have a significant change in our life in order to see who would be the right person. It's very, very important to check your beneficiary designations. Companies these days are changing softwares and computer programs like there's no tomorrow. And what I mean by that is if you have put power, you designated a beneficiary on your IRA, your 401k, your 403b, your life insurance, your annuity, and that product was sold, or even just like sometimes, you get new statements. They look different, right? From your investment accounts. They just look different. Well, that company changed software. Not all data transfers appropriately. And that's what we've seen a lot is that there's no beneficiaries on designated, even though they're like, no, I did it 22 years ago. I don't care. Double check. And a lot of times, sometimes they're online and you can see it online, or you just ask them. I prefer calling and saying, please send me a written copy. And then I keep that in my plan because we've had to go after companies saying that there were no beneficiaries. And I said, I've got a piece of paper right here that says there is. And that ended the fight right there. And then it's very important that you let some sort of responsible person know where the documents are located. I have some clients who are very private. So what they do is they've left a card on their fridge saying, if I die or get sick, call my office, right? Because they don't want anybody to see what they've done in advance. I'm not a big fan of that. I do think it's important that we don't share too much because they're amendable, they're revocable, and you may want to change it. So I think some privacy is warranted. But letting the major decision maker know, like, hey, if something happens to me, my healthcare directive and my trust or whatever are on the second shelf in the study, or they're in the, wherever it may be. I think that's important because how else are they going to know? Powers of attorney for healthcare, those can be, the paramedics will always look in your glove box for it. And they will also at your home always walk through the kitchen on the way out and look on your fridge. Those are places that they're trained to look for them. So I see a lot of questions had come through. So we're gonna stop here and kind of see.
We got some good ones coming in, Kim. So I'll start at the top if you don't mind. So
Yep.
we have a question. So are homes exempt from eligibility planning qualifications?
The short answer is yes, and we're going to get into that in detail in the second half of the presentation. But the
Perfect.
short answer, yes.
Excellent. That's good to know. Next, does a spouse need to have a conservatorship to care for a spouse?
So a conservatorship is only necessary in the event that your spouse or anybody becomes incapacitated such that they cannot sign a power of attorney either without support or with a supported decision-making agreement. So the answer is it depends. A spouse, if the person lacks capacity, if one spouse lacks capacity such that they cannot appoint an agent, then a spouse would also need to get a conservatorship because you cannot act for your spouse without some sort of legal authority to. Marriage is insufficient. And that may seem counterintuitive, but I'm glad it does because it means that you have a healthy marriage. There are a lot of marriages that I have seen where they have so many secrets that they do not want their loved one, their spouse, to have access to their medical records or their financial records. And so that's why the law is the law.
Thank you. Excellent. One of our attendees has asked, we have the basic legal documents from living in Pennsylvania dated about 5 years ago, but are they still good for California?
Okay, so the question is, again, it depends. That's the answer. The answer depends on what it is that you have. So documents travel state lines. They cross state lines, it's okay. California doctors, financial institutions, they will accept other documents from other places. I will warn you, California, I say the same, that California documents are pretty much good everywhere except maybe Louisiana, and Michigan is really difficult for trust for California. But Louisiana, because they're under French law. But there's the Uniform Trust Act, there's the Uniform Power, like there's a lot of uniform laws. So everything kind of travels across state lines. But every state has their own state specific type things. California is like overly broad, so chances are if it works in California, it works other places. The problem is when things come into California is that they don't have the specific California requirements. I would recommend having somebody look at it. Please, Attorneys are notorious for either not understanding the laws well enough. So they're like, well, I'm just going to do brand new ones, or wanting to charge you for new documents, whether you need them or not. So what I say, if you have an attorney look at them, say, I need to know exactly why it doesn't work. And if they can't tell you, it's because they don't know. Because when an attorney is competent, they will say, this looks fine, it'll probably work, except you don't have this. And I guess a good example is like in a power of attorney. California requires that if you want to have your power of attorney add things to your trust, like just say, I bought a house, it's in my personal name, I lost capacity. Now my power of attorney does not have authority to put it in my trust unless the document says it. It's a weird California requirement, but so those are the types of things I would recommend having an attorney look at it, but I would have them be very specific as to why it doesn't work here. That is just the best answer. Don't forget, attorneys, doctors, architects, engineers, anybody who sells a service, if they're not comfortable with you questioning them, they're not good at their job. That's just the simple. If they get defensive, like a financial planner, if they get defensive with you because you want to know more information, please take your money and run, because they're probably stealing from you or they're just not competent. That's my opinion, because anybody who's good at what they do is very happy to be overly expansive with you because they want to show you how smart they are, and they really love what they do, because people who are good at things generally love what they do. So you want to make sure that, I think it will work like in any type of crisis. It's just a matter of how much. But trusts in particular are usually good across state lines. You're not going to be able to amend it generally, because as an attorney, I don't amend other people's trusts. I step into the line of their malpractice. I also would never amend an out of state, because I have to go line by line to make sure that you have everything I need. It's kind of like a grandfathering in. Like when you have a old historic home, maybe it's not historic, but an old home, it's not up to code. But as long as you don't do anything, you don't have to make it up to code. But let's say you want to add a room. Now you have to make the rest of the building up to code. That's kind of like a trust. A lot of things are grandfathered in, but if I amend one thing, it means I need to make sure everything is now up to code. And that would be too costly for me to go line by line. It would be cheaper for my clients for me just to draft a new one. So that's how I do it. And I think that's kind of the standard practice for most attorneys. So don't be surprised if they're like, well, I just want this little change. And they're like, well, I'm going to do a whole brand new one, because their malpractice is on the line. So that's why.
Excellent. And the same person has asked another question, so I just want to jump to that briefly. What assets need protection? New vehicles, bank accounts, RAs, although you may be getting to the next section?
When you mean protection, where's the action? Oh,
They
what
just said what
assets need
assets need
protection?
protection.
So protection is not really what a trust does. What it does is it avoids probate. It defines who can sign your name under certain circumstances. So any asset that needs a signature. So yes, a car, right? How do you sign title? That needs a signature. A bank account. Anything that doesn't have beneficiaries on it, that you will then that's what you need to put in a trust. Powers of attorney, again, like, so let's say you have an IRA. If you don't have a power of attorney and you're over, I guess 67, or well, it's almost 72, actually 72 and a half, and you have to take your required minimum distributions, who's going to do that? If you lack capacity, somebody has to do that for you. So that's why you need a power of attorney. So anything that requires you to act for that, like jewelry and things that don't have to be titled, that's an assignment, that's different. But anything that requires your signature, bank accounts, IRAs, houses, all assets, basically stock certificates, things like that, anything that would require a signature to transfer or to sell.
Thank you. All right, I'm gonna jump back up to the top real briefly. So it sounds like a conservatorship is avoided if the proper documents are in place. Is that correct?
Again, it depends. I swear that's like the favorite attorney line. Yes, the answer is yes in 99% of the population. The reason why it's so important that I want to really make people understand, people don't sign powers of attorney because they think they're giving up their rights. And they think that because their child is like, mom's got dementia, I'm power of attorney, I have all decision-making power. That is not true. But facilities don't seem to enforce this. Doctors, it's infuriating. The law is that an agent, so the agent is like, I appoint my child as my agent. My agent can never overrule me under any circumstance. So doesn't matter how dingy I am, right? I can, if I want to run around the streets naked, my power of attorney cannot stop me. The police can stop me, but my power of attorney cannot stop me. If I want to give all my money to the Nigerian lottery, my power of attorney cannot stop me. That is when a conservatorship is necessary. You need a court order if you want to overrule your principal, the person. So 99% of the time, the power of attorney is able to redirect people from running around the streets naked. They're able to take over because somebody lacks capacity. They're able to take over the banks and maybe change the account so that mom can't give all the money to the Nigerian lottery, right? A conservatorship is the nuclear option. We are required by law to find the least restrictive alternative. So we are to do everything possible to avoid it. But if somebody, like there are people who are just so combative that there's nothing we can do but a conservatorship, even if we have the documents in place. But 99.5% of the time, the proper documents is usually enough.
Thank you. All right. Our next question. My bank seems not to be able to add a beneficiary who is a resident overseas. What do I do?
Okay, banks are allowed to do whatever banks want to do. They have their own internal policies, and you can't force them to do what they want. They're going to say, then don't be our customer. And they have the right to refuse service, because part of the issues about naming a beneficiary overseas is they have to report that in certain manners, and they need to avoid any appearance of money laundering and things like that. So their internal policies are dictating that. You may just have to go to a different bank that it will allow it. That's the best I can do, because as somebody who has written policies and procedures for a financial institution, that has a lot to do with, they're not going to get into the liability just for your one little account. And that's the reality. And I hate to say it that way.
All right, our next question is a doozy, so bear with me on this, Kim, and you can read it as we go. I have a full estate plan that I wish to update. It has will, trust, durable power of attorney, DNR, pulse, and much more. Upon contacting a lawyer, I was told that they would not take my case. The lawyer was concerned that the current beneficiaries would refute the new estate plan because my wife has Alzheimer's and is not capable of making a decision. However, the lawyer would accept my case if I provided a medical report from a neurological psychiatrist showing my wife is capable. Such a medical report requires a 3 to 4 hour exam costing about $4,000. If I came to you for an estate plan, would you take my case without such a medical report?
Okay, so no. And the only reason is why is, so I do teach on this. So I have a feeling that this attorney may have also taught that, because I teach attorneys. I have a standard practice. I believe that probate code 810, as I said, you're presumed to have capacity. Probate code 811D specifically says a diagnosis alone is insufficient to deem you to lack capacity. I have done estate plans for people who have been diagnosed with Alzheimer's for 10 years, but I have a standard practice, and I do not waver for anybody on that practice, that if there's been a diagnosis, you need to have some sort of physician's report saying that you're capable of making this decision. If there's anybody in your life claiming that you have dementia or some sort of other major neurocognitive disorder, I require that as well. And the only reason is that it's always or never. And so it's the standard practice, because as an attorney, my job is to make sure that estate plan is upheld. And as your drafting attorney, after you pass or something, that we're going to get deposed and we're going to be on the hook. And so our duty is to make sure that it complies. If there is a diagnosis, then there is a mispresumption. There's a bias in the court system. There's a bias in the average population that a diagnosis of Alzheimer's means you lack capacity. And because of that bias, even though the presumption is you have capacity, the standard judicial officer and other attorneys, and mostly neurologists, even specifically have that bias that you lack capacity. I teach a course on how to communicate with people with disabilities, and I teach a course on the elimination of bias for ageism. Those two combined are with neurologists that I teach that actually support a diagnosis of Alzheimer's with the right count attorney will be even a stronger estate plan, because there's so much more time and effort went into it, as opposed to like the one person that signed a document that didn't even know what they signed. I have a lot of people that come in and I review their estate plans and they're like, that's not what I was told it meant. And so they didn't even know what they signed. And so that one shouldn't be valid either. But because there's going to be a full blown litigation about it, having that doctor's evaluation makes it almost bulletproof. Like, because that is the proof that no, they had capacity. They just had deficits in these other things. So it is a very normal. Unfortunately, I do understand. So the neurologist that we used to have in San Diego that would do it for a reasonable value, a 2 or 3 hour report, they would only charge $800-900 because they were practicing neurologists. Those people have since retired since COVID. And so that is the standard right now that I do know of. There are a few other people in town that will charge less than 4,000. And if you want to just call my office, I can refer that name out to you. But any attorney that doesn't do it without it, I would be concerned about, because it's an invitation for litigation is the best way I can say it.
Thank you. That makes a lot of sense. And finally, one last question before we move on to our next section. If you have a living trust with a power of attorney over medical decisions, how would you take over, like, for instance, my husband's care if he's not able to make a decision? Do I need an attorney, and what is required?
So if you have the living trust with the power of attorney over healthcare, so an advanced healthcare directive with the power of attorney, the physician, so as I said, right, if you're capable of making these decisions, you stay in power. So your husband, in this instance, if he's at the doctor's office and the doctor thinks that he can make the decision, I don't care if you have power of attorney. The doctor will still have husband make the decision. It's when the doctor decides that he cannot make a decision, he cannot give informed consent, that is when the doctor will speak with you. So if you look at any power of attorney for healthcare, it will say it's effective immediately, right? And the probate code specifically says it is effective immediately, but it's only effective if a physician says that the principal can't make the decisions, right? Because you can never overrule your principal. And the problem that a lot of people run into in this world is that your loved one at 100%. Capacity is not 100%, not their 100%. It is the capacity necessary for the professional they're working with for specific decisions. And so that people find really hard, especially children. Like, well, my mom put a fork in the microwave. Well, I've accidentally done like tinfoil in the microwave too. It doesn't mean that I lack capacity. So that's part of the issue, but you shouldn't have to see an attorney for it because the documents govern. So you'll have to read them and see what's required. But generally, if somebody lacks capacity and you have these places, most documents say 2 letters of incapacity will remove them as the decision maker. And, so you can step in. Remember, you can't overrule them, but in the world of Alzheimer's and other major neurocognitive disorder, there is the therapeutic fibbing side, right? The redirection. We understand that they're not capable of understanding and reasoning anymore. So what we can do is we can say, well, we don't need to fight them. I like the really good example, and I hope everybody feels this one, of the 2 sisters that came in saying, I wish I was like my sister. And I said, why? And she's like, because she deals with my mom so well. Right? They're walking down the street, the 3 of them, and mom sees Elizabeth Taylor on the other side and wants to go get her autograph. And one sister, is like, Mom, that's not Elizabeth Taylor. And then the other sister is, Mom, oh my gosh, look, her hair is different. Let's not be those people. Let's not bother. And that was the redirection mom needed. Rather than fighting with mom, it was like, well, let's just be let's let her have she looks busy. We don't want to be those. And it really worked well. And that a lot of times when we have major neurocognitive disorders, being kind to their disease is a better plan than trying to fight their disease.
Thank you, Kim. That's such an invaluable thing that our organization teaches to people. I will make a shameless pitch about what we do here at the organization. If you need to learn more about what Kim is talking about, we have extensive education programs that can teach about some of the behavior management and how to communicate with people who are living with dementia. So excellent questions at the end. Thanks for putting those in the Q&A. Kim's going to go on to the next section, but keep on putting your questions up there if you have more, and we'll do this again in a few minutes.
All right. So strategies for financing long-term care. Oh, this is the hard part, right? What is long-term care? Long-term care is, I want you to learn the word custodial. Custodial care is care that is services and support in care settings that provide non-medical assistance with activities of daily living for individuals with physical and or cognitive disabilities. What does that really mean? Right? So Medicare, and we're going to go through this in more detail, but I like to kind of stop the things I hear the most. Medicare will not pay for your long-term care. Medicare and other insurances pay for immediate care, for cancer treatments, for ear infections, for rehabilitation after surgeries. They don't pay for providing food, bathing, dressing, and other types of things that are just basic needs, right? It's not a medical service, it's a support of caregiving. And that is really hard for people because I actually can't logically even figure it out myself because somebody who's suffering from a major neurocognitive disorder, it is a disease, but yet we don't provide services for it under our medical system. So that's where people get stuck and tripped up thinking they'll be okay. And so, what are the options if I can't get it from a hospital and I can't get it from a rehabilitation center? There's community options, right? There's in home care, there's adult day programs, and then there's the PACE program. In home care is multiple ways, right? You can privately pay, which unfortunately is not an option for all but 1% of the population at this point. I have to say it's pretty expensive if it's just out of pocket. We have, as a society, in particular in California, decided to increase the minimum wage to such a state that it's not possible for people to pay for in-home care anymore because caregivers are not minimum wage employees. And so when minimum wage went up, the cost of care also went up with it. And so you have to comply with wage and hour laws. That is something that is the most misunderstood point of in-home care that I've seen. The example, I have a caregiver that comes in. I'm going to have her live with me. I'm going to have her live. So her room and board is going to offset everything. I don't need to pay her when she's sleeping, all of these things that people think. That is not the law anymore. We don't have exceptions for in-home care providers, for nannies, for caregivers. They now need to be paid for every hour they're on in the home, whether they're sleeping or not. And that is a big shock to most people. Not only do they need to be paid for while they're sleeping, they need to be paid overtime. So time and a half if they're providing services or in the home for more than 8 hours, and then double time if they're there for more than 16 hours. Room and board is not as big as what people think. It doesn't match the market for how much it costs to rent a room places. I'm just letting you know that. So that is one of the biggest things. The bigger thing, if you have an in-home care provider, is that if you're not receiving it through a company, and you're not paying them through a payroll system, you now have issues with, are you paying them appropriately? People don't realize this. And I hope I'm not giving any bad guys any tools, but if a person wants to file a wage and a labor complaint, and that the state pays for that, they don't need to go hire a lawyer, and they're going to sue you personally. And I tell people a lot of times, the power of attorney for mom or dad, you become the employer, because you're the one deciding when and how they come and go. And if you're the one deciding when and where and how they come and go, you become the employer, which means you become liable. It is a very slippery slope, and I really want people to be warned. Also, if that caregiver gets hurt on the job, you don't have any workman's comp on that. And so a care company does. If they get hurt or if they're sick and they don't show up, what are you going to do? Those are the kind of things. I like to give the good example of, I had a client, she wasn't sure what she was going to do. She had this great neighbor that was going to do it. It's all wonderful. It's all fine until it's not. And I told her, be careful because most of these people get hurt. Um, Either they're lying or they're not. I'm not making a judgment call. I'm just saying they all seem to get hurt. They all get hurt lifting mom up. They trip on the wheelchair. I mean, all sorts. Well, that's what happened in this instance. The woman hurt her back lifting mom. And she called and left a message saying, thank you, thank you, thank you, thank you. And that message, and I called her back and she said, the next day, there was a lawyer knocking on the door to take photos of the house. So that was, and she hired a care company. And because of that, no liability. She didn't have to deal with it. And somebody new came in and it was their problem. So that is the one thing. Medi-Cal does help with in-home care though. So if you do qualify for Medi-Cal, and we're going to get in those numbers, then there is in-home supportive services, which is up to 283 hours a month. It pays a minimum wage. And they will help offset the cost of in-home care. It is a great option when you need a couple days a week, 4 hours at a time. You can pay right now. I haven't double checked with the county, but last I heard they were out of county provided in-home care workers, but you can have a neighbor do it. This is the situation where I see a lot of grandchildren. I see this has been really, really good for stay-at-home moms because now they can get paid and they can get paid on a W-2 such that they can start paying into Social Security so they can get Social Security on their own. There's been a lot of good ways to use this. So it's really good for family members. A spouse cannot get paid, unfortunately, but other family members can. So this is a great one, especially I see it works the best when there's a grandchild living in the house going to college or something like that, and that they can be the in-home care worker. The adult day programs are a savior for people because they are much less expensive than in-home care, and they provide that break of the daytime, right? If you are on Medi-Cal sometimes cover it entirely. If it's not Medi-Cal, they're still reasonably priced such that you can now drop them off, or if you're part of a PACE program, which is um, PACE is a more universal program, meaning that they will do care management, they will provide a lot more services, and it's through Medi-Cal. And now all of San Diego County counts for it. So there's PACE down in San Diego, there's the Gary and Mary West PACE program up in North County. And so what it does is they will pick you up from your house at 8 o'clock, take you to a day program all day. At 3, they'll feed you breakfast, they'll feed you lunch, they'll do all sorts of great things like music and other types of, therapeutic options. And then they'll bring you home. And why this works is that it provides a daytime break for the spouse or the family caregiver. This way people don't get burned out. It also works if, mom's living with me, but I'm still working. What do? I can drop her off at a day program. And that programs are meant to improve quality of life. So it's actually either delaying the progression of the diseases and things like that. And it provides really good options for your loved one. So the other options that become when we can't stay in the home, the residential care options. So residential care facilities for the elderly, that is a licensing type of facility. And so it's called an RCFE. And there's different types that we in the community, in the world, we define them as 3 different types, but they're all residential care facilities for the elderly, all RCFEs. And they're boarding cares, assisted living, and memory cares. Boarding cares are, like, you'll hear the word 6-pack. Boarding cares are the homes that are in neighborhoods that have 6 beds or less usually. Sometimes they're bigger, but the reason why there's 6 beds or less is because if you have a homeowners association, by law, they cannot prevent you from running a business out of your home if it's a boarding care. That's why you have those specific 6 beds. If there's no HOA issue, you'll run into ones that have a lot more beds. But that's what that is. And it is a tremendous option, especially for people with cognitive impairment. I really like them. More than I think I like anything else for people with cognitive impairment, because it provides a very strong continuity. And when you have some sort of major neurocognitive disorder, you need familiarity, right? There's transfer trauma that is a real thing. You need regular behaviors, you need regular staffing, you need regular residents. The more routine and regular things are, the generally the better life you're going to have, the quality of life. And so there are people who like pretty looking places. They like these really nice looking wallpaper and car, but they don't realize that we're looking for care, and every person's different. So board and care serve that purpose of people who are, especially, let's see, if they're high stress, then a familiarity place is going to be good. You're going to have the same caregivers coming in and out, the same 3 or 4, and they're going to get to know your loved one really well. They're going to get to know you really well. They're going to understand the needs, how to respond, how to react. There's a lot of really good benefits, and they can range in price dramatically from, $2,500 a month up to $15,000 a month, depending on what you're looking at. But they're usually a much better financial option. And that's why, they fit so many places. And just like food wise, they get to know the type of food your loved one likes, and then they'll, make that. It works really well. Assisted assisted livings are bigger places, like the cruise ships on land is the best way I can say. Some of them are more like dorms, like college dorms. It depends on the type you're going for. They're little, like a lot of parties are happening. It's kind of funny. I've heard some pretty outrageous stories of some of these assisted living parties. But assisted living is a great option because it's more like a apartment style living. So people that still want their autonomy. Not everybody wants to be in everyone's business, and this is a great option because it's bigger, and there's a lot more familiar. You can still have that familiarity because you have this little room that you're living in. It can be isolating though if you've got a major neurocognitive disorder because you're not involved in very many activities. And now the laws have changed, which kind of allow for people with a diagnosis of dementia to be able to live in assisted living, which is great because of cost wise. So if you're not a wanderer and if you're not a danger to yourself or others, then it's a good cost option. Memory care is an assisted living facility that has like a delayed egress or ingress, meaning there's some sort of like you push a door for 15 seconds and an alarm goes off and then you can walk through, or it's locked in its entirety. And so though that's really the only difference between assisted living and memory care is that it's a locked, secure perimeter facility. But they're generally more like apartment living with the restaurant. And then you have skilled nursing. Skilled nursing, you are going to hear when you're out there that skilled nursing facilities are rehab centers and that they don't have long-term care. They are lying to you most of the time. So a skilled nursing facility, if it accepts Medicare, it means that every bed in the facility is a Medicare bed. Medicare pays a lot to these facilities. They are very high paying per day, but they only pay for skilled nursing. So a skilled level of care, either rehabilitative services, such as you're receiving OT, PT, SP, speech therapy, or you're receiving some sort of skilled level, intravenous drugs, some sort of medical care that requires a skilled level of nursing. That's medical services. But Medicare will only pay 100% from 0 to 20 days. And then from 21 to 100 days, they'll only pay 80%, and your supplemental will pay a difference at a very large copay to you. Not all the time. Some people have different insurances, but that's the average. Medicare in general is going to give a notice, or the facility is going to give like a notice of non-coverage after 12 to 14 days on average right now, because they're worried they're not going to get reimbursed by Medicare. And so there's ways to fight it, but people need to understand that you have to be receiving and needing a high level of care, not custodial care, not caregiving. Just because you can't feed yourself, dress yourself, transfer yourself, that is not medical need. That is custodial need. So that's where I was trying to make it clear, like there's a difference. But most skilled nursing facilities will call themselves rehab places. But if they accept Medi-Cal, they're also, every bed in that facility is also a Medi-Cal bed. They will say, well, we have no Medi-Cal beds. And you say, well, that bed looks just fine that they're in right now. By law, they are not allowed to segregate Medi-Cal patients. So they get away with it by calling it a rehab wing and a custodial wing. Even though all the custodial people are on Medi-Cal, that's technically against the law if they're being segregated. Just so you know, when you do end up in a skilled nursing facility and you are there under Medicare, and they also accept Medi-Cal, and you switch payment methods to Medi-Cal, there is a statute that specifically says it is illegal to discharge you for a change in payment method, including moving to Medi-Cal. So I see a lot of inappropriate discharges. I see a lot of pressuring people, pressuring family members to discharge inappropriately in order to say, well, Medicare is not going to cover it, and we don't. This is not a Medi-Cal bed. If they accept Medi-Cal, every bed's a Medi-Cal bed. So that is just something that to kind of help navigate that. So I kind of talked about the cost. Oh, I guess I didn't talk about the cost of boarding care and assisted living and memory care. So in-home care, we talked about that. It's expensive. Day programs are going to range. There's a few in town that are very expensive. There's a few in town that are not. A lot of times there's books and things that have different programs that are available. I really always recommend going through PACE. They've got a really good list of all the best and what they have to offer. So the range in prices is so different. I mean, I've had people at adult day programs that the VA end up covering $20 a day. Medi-Cal most will usually cover 100%. And then if you're paying out of pocket, it just kind of depends. Boarding cares we talked about $25,000 to $15,000. It can range so dramatically, but on average, they're usually less than $5,500 a month, depending on the needs. Assisted living, again, I don't know of anyone that's under $3,500 a month, but those also can range up to $15,000 depending on your ocean view. Memory care is the same. If you're on the coast, it's going to cost more than inland. Like there are the same sister facilities, the same ownership, and they're the same facility, but it's cheaper inland than it is on the coast. It's just kind of one of those odd things. But be mindful about what your loved one is good for. I've had a lot of people care more about how the facility looked than the services being provided. Especially when we're talking about major neurocognitive disorders, your loved one may really benefit from the services provided at an active care, right? Like they are, your loved one is improving. They have got this great quality of life, but we're talking about a progressive disease. So while transfer trauma is true, and I want people to create the plan. That's why the plan is so important, right? You don't want to keep moving people around, but you may have a facility that is expensive and you're like, this is not sustainable for a long term. But for the time period in which your loved one's there, it's a good fit for a short time because they're doing well. I've had a lot of people go to a higher end facility, we'll call them, because they're sometimes you're paying for in a higher level of knowledge, not just because it's pretty and has an ocean view, but sometimes you are like, these are people that specialize in people who are difficult patients, difficult residents, right? And they're really good at managing medicines and finding the right program and system to get somebody qualified. And this is let me give the example is I had a facility where I just loved this guy. He was great, but he had been kicked out of 4 facilities because he was very combative, very combative. And when you went to the facility, this facility in particular, he has this FBI hat on and like this walkie-talkie, and he's, he welcomes you every time you walk in the door and he helps you get to where you're going. And so after being evicted from 4 other places because of behavioral issues that they just couldn't handle, this new facility said, sir, what year is it? And he said, 1974. What do you do for a living? He's an FBI agent. He's a retired FBI agent. This facility gave him the FBI hat, gave him a walkie-talkie, and gave him a job. He secured the perimeter. and having a job, checking people in, making sure that their credentials were up to date. He thrived at this facility, and he was be able to take down all of his meds. It was incredible because they understood how he worked. I've had another facility where a woman was very intrusive and was, going to be evicted because of her behaviors, because she kept interfering with people and like waking people up. And they figured out that she was a retired nurse and that she was going to do checks. Like she was waking people up as if she was going to do, some sort of medical check on them. So they did. They did the same thing. They gave her a nurse's station and they gave her a job, like jobs. And so it was just time. And so they got her regular for like, nope, that's not your time. They gave her jobs. It was quite incredible. And so those places were higher, more expensive. But once the family and them all understood how to work with this patient's disease, they were able to then find a lower cost in the long run and be able to sustain it. So that's where I tell people it's not an all or nothing time. Like sometimes you just need to, spend a little extra to understand what's going on. Once we understand how this person's disease works, because everybody's so different, then you may be able to take them to a lesser expensive option. Skilled nursing care, I didn't look up before today what the 2025 numbers for the average private pay rate in California is, but it's well over, I think I want to say we're at $12,000 now. That's a month average private pay in California. It's an average, so it includes Apple Valley, not even mixed with La Jolla. So San Diego, we're looking at about an average of $15,000 a month, which is why most skilled nursing as a custodial option is not an option unless you are on Medi-Cal. So how are we paying for it, right? So I'm going to keep banging this drum. Medicare does not pay for it. Your health insurance does not pay for it. They pay for doctor visits, for prescriptions, sometimes depending on the Medicare you have. They pay for acute medical conditions. They do not pay for major neurocognitive disorders. So long-term care costs are not covered. Your medication is, but your long-term care cost is not. So how do you pay for it? You pay for it through your personal savings and your assets. So a lot of times if long-term care insurance is an option for the people who purchased it before, but I've looked at the numbers recently and I kind of do the math and I say, if you can afford long-term care insurance these days, you're better off paying out of pocket because you can probably invest it better than the insurance company will. It's just that expensive. So if you have it, that's great. Managing it and getting it to pay has been a big issue for a lot of people. It's getting kind of better because there's been enough bad faith lawsuits, but you're asking people to give up money. And in general, people aren't going to want to do it. So long-term care insurance, you have to be perfect in your claims process. So I tell people start early, get the information early, find out what you're going to need to do because it is a process. But if you do it right, they can't deny you. It's just the fact that a lot of times they won't. I want this to be heard because it's important. Whether you're getting in-home supportive services through Medi-Cal or whether you're getting a long-term care insurance policy to pay, you are going to have an evaluator come out. And that evaluator is very important. Now, people, their ego and their pride has been the biggest barrier to people receiving support that I've ever seen in my life. And then they come in mad that they're inappropriately being denied or they didn't get anything and they're mad. And I say, okay, well, tell me what happened. And they described to these evaluators their best day or things like, well, I take care of that for my mom or my spouse. Wives, I'm telling you, you are the cause of so many denials that I just don't know what to do because you're caring for your husband. And well, so then your husband doesn't need any care. And people don't quite understand that. You need to describe what the person who needs care does and what they cannot do, not what you're doing for them. Because if somebody else is doing it for you, they don't need support for it. So you need to say they can't get the mail, they can't dress themselves, they can't cook for themselves, they can't, wash their laundry, they can't change the bed. Not that I get the mail, I go grocery shopping, I make it for them. Not that because somebody's doing it. So you need to change the way you speak about it, and you need to say what they cannot do for themselves. That's how you define it. I hope like that can resonate. I want to even say it again, because when you're having somebody evaluate your loved one for services, for any type of benefits or insurance coverage, it is not what you do for them. You need to define their worst day and what they can't do for themselves. You are not Superman this day. I can't tell you how many people, right? The husband's laying on the bed, on the couch, dying of the cold, but then they go to the doctor and they're fine. We are not Superman this day. We are defining our worst day. So if there's a few things I want people to take away, that's one of them. Please let your ego and your pride aside, because we have to be honest, because this is the time. So what other financial tools are there, right? Reverse mortgages. These are something that I recommend the least, but end up working out the best when done properly. And I'm going to tell you why. A reverse mortgage is a great arrow in my quiver, but it does not work for everyone. Most people in San Diego County in particular, their home is their largest asset. It is the best tool they have for paying for ensuring a quality end of life. If you get a reverse mortgage too early, then you will eat up your equity in your home, right? And so right now, we have reverse mortgages you can't get more than 50% of the value, which is great. But if you get a lump sum, the interest is going to earn on that lump sum, which means let's say you have $1 million home and you take $500,000 out in a lump sum. You will have interest burning and earning on 500,000. You don't have to pay that money back, but for every month, that $500,000 you owe on the house will get bigger and bigger, and it'll compound on $500,000. And so let's say, I can't tell you exactly, but I'm going to say in a couple of years, you have no choice but to move. You may now only have $200,000 in equity because that $500,000 turned into an $800,000 loan because that $500,000. What did you do with that $500,000? I bet you didn't earn interest that was the same as your interest rate that was eating up on your $500,000. So what I recommend is, and now reverse mortgage guys are going to hate me for this, but when you get a reverse mortgage, the loan officer gets paid substantially more on a lump sum than they do on a line of credit. So they are going to push you and sell you on a lump sum. The lump sum is 90% of the time the worst idea. It works in some instances because if it's a large enough sum and you can invest it properly, you can make more money, and then it's a better plan. But that is a unique situation. What is a better plan, and I want everybody to think of this, is if you're going to do it, you get a line of credit. You get the $500,000 line of credit, and you only pull the $2,000 a month or $2,500 a month or $3,000 a month, whatever it is you need. And so now your interest is only compounding on $3,000 a month and then $6,000, not $500,000. I hope that math kind of makes more sense. This way, if you have to sell the home or even just leaving a legacy for your loved ones, when you die, there'll be more equity left in that home. And so the idea is, how do we preserve it? And so my experience, and the reason why reverse mortgage guys get such a bad rap, is because they are bad. Not all of them, but they sell people on the lump sum so they can make a bigger commission. So shame on you. What they should be doing is doing the math for you to explain that, yes, I'll get a lesser commission on this, but it's better for you to not take the lump sum. So I love the idea. I just think that that industry is fraught with people with no souls. But there are some amazing, I actually have some really good referrals for people who have souls and use it as an appropriate tool. Charitable gift annuities are great options. This is for people who have highly appreciated, like let's say you have a highly appreciated rental property that's not bringing enough, or a highly appreciated vacation home, something that if you sell, half of it's going to taxes. A charitable gift annuity is a great plan because you can donate it, I'm putting it in quotes, but to some sort of ultimate charity in the long run. But you can, so Alzheimer's, they need is a good example. You can you can put it in a charitable gift annuity such that you can get paid a monthly amount out, and whatever's left after 20 years, because you can give it to somebody else, the remaining goes to charity. But you don't have to incur that capital gain all at one time, so that you may end up getting the full value out of that sale to pay for your care. And so, and that, and even though there's going to be a tax that's coming out, you're now offsetting it with these, high costs of care. So there's a tax, like we can play a game. I always say your CPA gets involved and we all play a game together to manage, like, how little can we give the government while you get the maximum for your care. You also can convert life insurance. So in the olden days, we weren't allowed to do this, but there is now a change in the law. It's been a while now, 10, 15 years, but don't stop paying on life insurance without evaluating whether you can sell that life insurance. It is now a way to sell life insurance in order to pay for long-term care. So let's say I can't afford the premiums on the life insurance anymore, but I can sell it to somebody who can, and now I can use that money to pay for care. So that's an option that people don't even know that exists. We've got Medicaid, Medi-Cal, Cal-AIM. I'm going to flick. Okay, I just want to make sure I don't, that there wasn't a slide. I thought there was a slide specifically on the Medi-Cal map, but so bear with me, everyone. There is. Okay, so I'm going to jump. So there's Medi-Cal, Medicaid, Cal-AIM. So I'm just going to kind of say that those exist, and then VA benefits. So tax deductible expenses. Some healthcare and long-term care expenses are tax deductible. That I was just saying how your CPA is going to be part of your team, and they're going to have the most fun playing a game, because most CPAs love to play the game of how can we avoid all taxes possible. So and we're not talking about a tax preparer. We're talking about a CPA, somebody who has the really strong knowledge on how we can go ahead and maximize the estate. So tax credits and deductions: in-home care services, custodial or skilled; residential care services, custodial or skilled; non-covered medical expenses, personal care items, medical equipment, modifications to the home, long-term care insurance premiums. These are all things that can offset your income. So there has been a change in the law when it comes to IRAs, 401ks, or any ERISA plans, any of your retirement, your pre-tax dollars. If you left those pre-tax dollars, your IRA, to a non-spouse, non-minor, or a non-disabled child, and those are the exceptions, but if you leave it to a standard child, that child has to incur all of the taxable income over 10 years. So I tell people now that the law has changed, and that was it, the Secure Act, if you want to Google that. The Secure Act basically punished people for inheriting retirement accounts. You want to start spending that money first when you need care. And this is where you have to get your CPA involved. You're looking at all of the deductions. If I have to take money from my 401k, that is now taxable income. If I am incurring medical expenses because of my long-term care, I can now deduct that, right? There's a maximum, or a minimum amount you need in order to start doing that. You and your tax man or lady can play a game on how much do I take out of my IRA every year with the offset, so I don't have any income tax burden on this. And it can be a really fun game for a lot of CPAs. They have a good time with this. So all of a sudden, it's not as much of a burden as you thought it was. And so these are how we do it, right? It's a bigger picture how we do it. And now you're not spending any of the money that's going to go to your loved ones, your heirs, and their legacy planning that will be taxed upon receipt. So it's a win-win for everybody. Employment considerations. This is something that if you're still employed and you have a diagnosis, this is hard, because we don't want you to get fired. We don't want to get you fired because of your need for care, or because of some sort of cognitive impairment, because there's a lot of issues related to it. Number one, it's a disability, and it's a protected disability. But if you don't request those accommodation and don't disclose it, they are not responsible for it. So how do you disclose it? How do we do it right? There are a lot of employment attorneys that kind of work through this. So you're going to want to look at it. But a lot of bigger companies have things um, in their provided services and other benefits programs that may help, right? Because there's short-term disability products, there's long-term disability insurance that you may not know is an option through your employer. You have Family Medical Leave Act benefits. There's early retirement options I've seen with people. So it's important to kind of talk to the employer, and even if it's just a pre-talking to them saying, what, hey, what are the benefits that I may not know I have? And then it's also important to figure out how to disclose it, because getting fired because you didn't disclose it because you made mistakes because of your cognition issues, there's not much you can do about that. There is the compassionate allowances that I want everybody to know about. It may not apply to you, but it expedites the processing of your SSDI claims, right? Your Social Security Disability Insurance and your SSI, which is your supplemental security income. SSDI is if you have a work history, you have 10 years, 40 credits of work history, you would be entitled to Social Security Disability Insurance. This is you paid for it, you get it back. If you have less than 10 years of employment, W-2 employment, paying taxes employment, like a lot of people, who had businesses and things paid themselves under the table when they don't have a work history. So that would be a supplemental security income, SSI. Those are for a minimum amount of money that the federal government says people should get if they have a disability. And so if their medical conditions are so severe that they meet the definition of a disability, they will get expedited processing, because these programs can take a lot of time. This is the list of what is on that compassionate allowance list. So the FTD is probably the most common one that I see, because that onset's usually fairly early. So the young onset Alzheimer's disease is not as common, but FTD usually comes in it starts in your 40s, and then the 50s it becomes obvious. That's the most common that I see. Lewy body is also another one that impacts the younger folk, I want to say. But in my experience, that's what we see. But any of these, whether it's primary, aphasia, the progressive subnuclear palsy, like these are the ones that it's important that if you have them and you are not of retirement age, such that you're getting your standard Social Security, these ones will get you expedited. All right, so veterans benefits. There are a lot of benefits that veterans are entitled to for their service. Most people know about them because you get this book as you're discharged. I'm going to talk about the ones that are a little paragraph in the middle of the book. But your health insurance, your medical care, your service-connected disability, right? Those are the ones that people know about because, look, I got shot, I have a leg, issue, or I suffered from PTSD, I lost some hearing, I've done, and you get rated, and you're discharged with this rating. A lot of times, your service-connected disability those disabilities can arise as you age. So you may not have received it as a rating on your discharge, but you do end up needing it as you age. So I had a client came in all hunched over. He was only like 71, 72, that he just was just very debilitating it just looked like it hurt to be him. And he was telling the story about when he was at boot camp. I want to make sure I get it right. He was a Marine at an Air Force camp, or an Air Force and a Marine. Now I can't remember what it is, but they thought it would be funny to put an extra charge in it was how to escape, like the parachute from the plane. I think he was a Marine at an Air Force. Well, they put an extra charge in it, shot him up. He ended up being stuck at the top, broke his back, all these things. But as a healthy 18-year-old man, very muscular, he healed well, everything was fine, never had a problem. It wasn't until he was in his late 50s that he started to have some back problems from it. He always knew it was because of that, but he didn't really do anything about it. So I recommended him going down to the VA, not the hospital. VA medical is not the same as veterans benefits. Those are two different offices, and their computer systems don't talk to each other. I know it sounds infuriating, but they don't. So you have to go to one, and then you have to order your medical records from the VA medical system. But he ended up getting 100% disability, and now he's getting a check for, I think, $7,200 a month. And he didn't know that was an option, but all he had to do was go, because there was proof in his medical record that because of his service, he broke his back. And now as he aged, this is the result of his aging. That that disability didn't show itself till later, but the cause was his service. So that's service connected disability. There's also pension benefits. And pension is non-service connected. Pension benefits are the result of your actual service, right? So what I mean by that is, if you had 1 day of service during a wartime period, and you can Google the wartime periods. I don't think we have the chart in here, but it is a specific time frame, right? Right now, unfortunately, we're in like this gap of Korea and Vietnam that I see a lot of people age-wise. But if you served for 90 days total of active duty, and active duty, I've had a lot of reservists who this doesn't apply to, but active duty, and one of those days falls within the period of time in which the VA says is a wartime. Keep in mind, the Persian Gulf is still happening. They haven't even closed that time frame up. So the time frame is not just when we were shooting at people. But you never had to see combat. You could have been sweeping a floor in San Francisco during that 1 day of your wartime period. As long as you served 90 days total active, one of those days fell within the wartime period, you are service eligible, as long as you were more than dishonorably discharged. So you could have been medically or honorably, or the other three. But as long as it's more than dishonorable, you are service eligible. Now your eligibility is going to have to be based on, are you receiving care? Do you need care? So if you're receiving care, then you may be entitled to a reimbursement, and you have to qualify 2 of the activities of daily living. Excuse me. Bathing, dressing, feeding, toileting, transferring. They did add medicine maintenance recently. If you are receiving assistance with 2 of those, you are now medically eligible. Now, are you financially eligible? You figure out if you're financially eligible for non-service connected. That is just because you serve. That means that if is your net worth, and again, I don't think they've released the 2025 numbers, but I don't have them off my top of my head. But let's just say it's like $154,000, because that is close. That's your net worth. And your net worth is calculated based on all of your assets times your annual income. So your home does not count. So if you only have $32,000 in the bank, and you only make $82,000 a year, you are going to be financially eligible. The issue is whether you get medical or whether you get reimbursement, is, are you paying at least your income? So it's your income plus $1 is the example I use, because it's really times 5%. But are you paying your income in care? So if my income is $3,500 a month, and I'm living in a boarding care at $4,500 a month, VA will reimburse me the $2,100 a month, or whatever amount I'm eligible for. And that's just a calculation on whether you're married, whether you have dependents, things like that. The surviving spouse is also eligible for something. They get a lot less, but they also are entitled to something. But you do have to be expending the money to receive it, because it's a reimbursement, and people don't quite understand that. But what it's really good for is, it can maybe be good for keeping you at home. The problem with the home thing is that you have to spend all of your income on medical care. That means that they don't care what your electric bill, your water bill, all of your other bills are. So it really works well for facilities. Why? Because you don't have any other expenses. So if all of your money is going towards the facility, you now can increase the type of facility. If you're going to get an extra $2,000 a month, you just went into a different level of care. So that's what it's really good for. The traditional pension benefits, that would just be you worked for 20 years and you get your pension benefit. Death pension, if you are receiving service-connected disability income and you had it for more than 8 years or you died from it, your spouse would be entitled to a survivor's pension, a DIC, a dependent indemnity compensation. And then if you are a caregiver for a veteran, there is a VA caregiver support program, and it provides a lot of services to the caregiver. So the caregiver support program, you've got adult day health, you've got home-based primary care programs, you've got homemaker and home health aid programs, you've got telehealth, you've got respite. I tell everybody, if you don't know what respite is, it's because you need it, right? Respite is you as the caregiver taking a break. Sometimes it could be your loved one ends up taking a vacation for 3 or 4 days at a facility, so you can take a break. Sometimes it can be just a day, having somebody come in and stay in your home for the day. There's also skilled home care services and then home hospice care. So these are all the things, if you are a VA, if you're a veteran, your loved one's a veteran, you want to really look at the services they have. Okay, Medicare. I know this is a lot. This is a lot to intake, which is why we're sending the slides. Medicare, this is your insurance. It's your insurance just like Blue Cross Blue Shield, like Anthem, like Kaiser. It's your insurance. It is an entitlement program. It's not based on your financial need. I don't like the word entitlement. You paid for it throughout your life and now you are getting it. It is like prepaying for health insurance is what you did. Structure, Part A, everybody is entitled to Part A and Part B if you paid into it. Your hospital insurance and your medical insurance. Who's going to pay for your doctor? Who's going to pay for the hospital stay? Part C, Part D, Part F and G and N are all voluntary, right? So you can have private health insurance, prescription drug coverage, and then Medigap plans, which are supplements. So some people will get an Advantage plan. That would they take over your Medicare, but the same Medicare rules apply. And a lot of those don't have any co-pays and things like that. So they do work well. I will give my warning. This is my flashing light warning to people who are choosing their Medicare programs. For some reason, a lot of Medicare, because they don't do it for a living, so that's why. But a lot of Medicare insurance brokerages don't really warn you of this. So we all think of the ACA, the Obamacare, there's no pre-existing conditions. That doesn't apply to Medicare, okay? There are pre-existing conditions still in place with Medicare. What does that mean though? It means that whatever Medicare insurance you purchase, like whether it is the Cadillac or a bicycle, right? If you get Advantage plans are the best example because they are usually they're usually free, or they're the lower quality, kind of like your HMOs versus a PPO. But if you have a medical condition, you cannot go up to a higher Medicare option unless you don't have any medical events for 2 years. So there is a pre-existing condition situation. And so people, when they're 65 and they're picking their Medicare, they're like, well, I'm healthy, I'm fine. Yes, but if you're not healthy and you're fine and you want a better Medicare, you cannot go up. You can always go down, but you can't go up. It's very rare that somebody who's receiving Medicare doesn't have some sort of pre-existing condition, high blood pressure, diabetes. I mean, you name it. It's almost like don't go to the doctor for 2 years and then you don't have a pre-existing condition if you're going to switch Medicares. But don't do that. Please see the doctor. But that's the issue that a lot of brokers don't do. And I want everybody to kind of consider that because I like my aunt as the perfect example for this. She's got the Cadillac. And my goodness, she's now got so many things and she has no problem seeing physicians because they all want her. Why? Because a Medicare Advantage plan does not reimburse as well as the Cadillac does. And so doctors, it's a business, right? They have to make money somehow. They're not going to put all that time in medical, they're not going to go to medical school and put all that time and money into getting all those student loans if they're not going to get paid for it. So it is a business. And the higher end Medicare you have pays more. So she cannot, like, man, I mean, I don't know how she knew this much that long ago, but it's amazing. But she's been paying for it. So it's a math problem. It matters a lot when you're talking about skilled nursing levels. Like when you get discharged, she has a lot more options because hers pays a lot more. So that's Medicare. Medicare and Medicaid are not the same thing. Medicare is not paying for long-term care. Remember, I told you there's that 1 to 20 and then 21 to 100, and then very few people get 100 days unless they have TRICARE for life. If they have TRICARE, so if the VA is covering if the VA is their Medicare supplement, those people usually get 100 days. But other than that, it's a rarity. Medicaid. California is special, as you all know, and we like to call it Medi-Cal. We're not the only special ones. Massachusetts has MedMass, but Medi-Cal is an island, right? California, we are very special. We have rules that apply here that do not apply anywhere else. So everything I'm going to say to you today does not apply in Arizona, Nevada, Oregon, Washington. I don't care where you go. 49 other states do not agree with anything that we do in our Medi-Cal system here in California. But it is still Medicaid, meaning it's still funded by the federal government. It is a needs-based program. It says jointly with state and federal Medicaid funds, but it's really funded substantially by the federal government. It provides free or low-cost health coverage for children and adults with limited income and or resources. And it does pay for medically necessary healthcare services. I've had a client who had like over a $1.8 million medical bill, and Medi-Cal covered that. And they weren't financially eligible for Medi-Cal. Those issues we're not going to talk about today. But because Medi-Cal, Medicaid, it has been perverted, is not the right word, but it has been turned into this free or low cost health coverage for people of lower incomes. Really, what it focused on initially in the legislative history early on was preventing the pauperization of spouses. So my mother had a real problem just mentally with this. So I think a lot of people have a block with Medi-Cal, thinking it's Medicaid, it's for people who are not me or whatever. That's not what it is. It really it was created to end the pauperization of spouses. And I want people to kind of flip that script, because what happens is you look at the olden days, right, when it was created, and that, a husband would end up getting Alzheimer's, wife has no work history. These are, remember the olden days, we're talking about the 70s. And, all the money would be spent on paying for care for husband, and wife would end up homeless eating cat food. And those are the fears, and that's what Medicaid did, is it provided long-term care options for protecting the middle class. And so it's a spousal protection situation. And when you look at the legislation, the history, and where it is still today, your home is always exempt. Why? Your home is always exempt because we do want wealth transfer. And we're not talking about a super high net worth wealth transfer. If people can afford to pay for care, they should. But the idea is, if you have to spend every penny such that you can't leave any type of legacy, wealth transfer from generation to generation is how people stay out of poverty. It just mathematically is, especially as inflation and things like that happen. So that's one of the things I want people to realize, is that this is an option, but it has to be used properly. So how are you eligible, right? So you are eligible if you're on SSI. That SSI is, remember I said, people with no work history who have a disability. It is an automatic Medi-Cal. And then also individuals whose income makes them ineligible for public benefits can also qualify as medically needy. I kind of explained that there are these options. But it's really important for the concepts of share of cost and estate recovery. And we're going to walk through that. I think we do. Maybe I'm going to say it right now. Okay, share of cost. Share of cost is Medi-Cal's words for copay. But let's say I have my health insurance. I have a $30 copay every time I go see a doctor, and $5 for every prescription. That's not true, but that is the olden days. Medi-Cal does the copay, but they base it basically on your income, and it's a math problem. My share of costs will be basically the math of what I can afford based on my income. And estate recovery, we will get into, I do know, but that is anything that Medi-Cal pays if you're over 55 and it's a skilled nursing level of care or some sort of custodial community based as well. They want back after you die, but they can only get it from your probate estate. Remember, we're going back to the beginning when I talked about the importance of a trust, because if it's in a trust, there's no probate. Why? Because you've decided who can sign your name after you've died. Probate is only a judge deciding who can sign your name after you die. And so if you've already decided that, whether through beneficiary designation, so we call that operation of law, meaning that on my bank account, my transfer on death account, it says that when I die, it goes to this person. That is a contract I entered into with my bank that says when I die, it goes to this person. That is operation of law. And in your trust, it's like, well, I don't have that because I don't do transfer on death deeds. I don't like them personally because they're fraught with problems. And it's also a statute that sunsets and it has to keep being renewed. So I'm nervous. I, as a lawyer, will not do them. But because a trust serves that and doesn't have all the potential negative consequences. But anything you can transfer without a probate is not recoverable. So that's important. I'm going to keep saying that because I want people to understand the importance of it. Medi-Cal for long-term care. What does that mean? So as I said, Medi-Cal is not just health insurance and it's not just low income. What it does is in-home supportive services. I talked about the options for home. If you can stay at home, that's where you should be. We have a public policy in California. This was old Reagan times, right? He closed the institutions. We're kind of seeing the impact that has now, for good reason at the time. But the public policy in California is that it's against being people institutionalized. So we want to support being in the home. So community-based services, which is the assisted living waiver program. So living in a community, residential care facility for the elderly, or in-home supportive services, getting care in your own home. Those are what we're trying to do, right? That is what we like to do. Assisted living waiver program. Keep in mind that is an option, but the wait list is so long that it's not really sustainable for a lot of people. It can be 7 to 11 months long. There's only 7,500 beds, I think, in California right now. I think in the long term, it will increase because of the changes in the law that we're going to get into. But we want to avoid skilled nursing. And so Medi-Cal will cover skilled nursing facilities at 100% of your income, less $35 if you're single. And if you're married, we're going to walk through those numbers in a bit. Because Medi-Cal eligibility, this is some big major changes that happened. There was something called SB 133, which was the elimination of the asset cap for eligibility. That it was actually, it should have said January 1st, 2024. I don't know why that says 2025. I'm sorry, I have a typo and I didn't see it. So effective January 1st, 2024. The asset limit for non-Magi Medi-Cal programs, which is just basically based on your income, it's eliminated in its entirety. So in the olden days, you could only qualify for Medi-Cal with $2,000 in your name. You could have a residence, you can have an IRA or other retirement account of any value. You could have one car, you could have like a certain type of business, blah, blah, blah. Then in July 1st of 2022, that number was increased to $130,000 plus the residence, plus the IRA, plus those things. But as of January 1st, 2024, it was eliminated in its entirety. What does that mean? I use the example of Bill Gates, not because I know this for a fact, but I read an article a long time ago that Bill Gates pays no income. So according to Medi-Cal's current rules, Bill Gates would qualify for Medi-Cal because Medi-Cal became income only based. His assets, billions of dollars, are irrelevant for purposes of calculating whether he's qualified. The question would be, are all of those billions of dollars making any income such that they would disqualify him? What it means, though, that's for a single person. So our income being our only concern. But if you're married, the spousal protections are still in place. In the olden days, that means that if you were married, the sick spouse could only have $2,000 in their name, the well spouse could have $138,000 in their name, blah, blah, blah. Well, we don't care about the assets anymore. Assets are irrelevant. Again, you could have $12 billion, and as long as it was all in Amazon stock because it doesn't pay dividends, then there's no income produced by those $12 billion. So you would qualify. So, but the amount of income for a spouse, so to qualify for Medi-Cal as an individual, you can have only $1,732 in your name. But if you're married, you now have the MIMNA that allows for more income in that spousal community, right? It's the minimum monthly maintenance needs allowance that is determined by the state under federal guidelines. So California, the feds say how much it can be, and California always picks the most. It's a range. And so in 2025, the well spouse gets to keep $3,854 of the sick spouse's income if they don't have enough. What does that mean? That means I keep checking the slides because I can't remember. We have so much information that's been coming through that there's a lot to go through. But what it means is, let's say that the well spouse that has $1,000 in her name, and we'll just make generally, we'll say the well spouse is the wife, sick spouse is the husband. Well spouse has $1,000 in their name, sick spouse has $2,000 of income that they receive. So if the sick spouse gets sick, right, and needs to go into skilled nursing or any type of other Medi-Cal that will be covered, the well spouse gets to go up to $3,854. So the well spouse gets to steal the sick spouse's $2,000. So now they get all $3,000, and the sick spouse has a zero share of cost. So they will receive all of the Medi-Cal benefits without any out-of-pocket cost. Let's reverse that, though, and say that the well spouse has $5,000 of income and the sick spouse has $1,000 of income. What that means is the well spouse gets to keep $3,854. They don't need any more money because they have $5,000. So the share of cost of the sick spouse would be $1,000 minus $35 for your personal needs allowance. But let's just say, so their full share of cost will be all of their income. I don't know if that made sense. I'm trying to make it really simple in math, but just know that the well spouse's income is really irrelevant unless it's under $3,850, right? $54. Then they can take from the sick spouse. But that's how you decide how much your share of cost is. And that's how you decide if Medi-Cal is an option. It's not an option for people because sometimes their income is just too high. So, I always say they're too wealthy, which is ridiculous because these numbers in San Diego are nonsense. But that's how the math works out. There are options. So the options are what happens if, I have too much income. Well, there's something called the name on the check rule. I did not make this stuff up. This is really the name. The name on the check rule allows the community spouse, what I'm calling the well spouse, to keep all of the income received in their name, regardless of the amount. So I've had spouses, someone gets sick and they have a rental property. The rent check was going to both spouses. We make the rent check just go to the well spouse. Now it's not counted as income. I know that sounds insane, but that's all it takes. I've had people just take the sick spouse off of investment accounts that are high income producing. That is where we have issues now. And I'm teaching this mostly. So I teach this with Alzheimer San Diego, but I'm really focusing this program on financial planners. And I'm really hitting them hard for one reason, is because I want them to stop selling assets, selling investment products to people that guarantee a form of income to one spouse and not be able to change it to the other. Because if you've got a portfolio filled with a bunch of annuities, number one, before you buy an annuity, please check, because annuities are good for one person, the annuity salesman. So, but sometimes they fit, right? But if you've got a bunch of annuities or other financial products that are kicking off income to one spouse and you can't change it, that means that one spouse will probably never qualify for Medi-Cal. So because the name on the check rule is, I don't care how much money the joint household is getting. I care about how much money the sick spouse is getting. And that is where the name on the check rule comes in a lot now. 3,100 petitions, that is a court procedure in which we can allocate all of the income to the well spouse. Because these rules are so new, there is another attorney and I in town that have tried many times to file these petitions to educate the court on what we're trying to do. In the olden days, we would be able to get them rubber stamped because we were moving assets around. Now that assets aren't an issue, income is new. And so this is a new petition. Unfortunately, each client that we've had who fits this really well, because it has to be a really good plan and one that's easy for a judge to understand, they keep dying on us midstream. So this is an option, but we just don't have a lot of whether it's going to work or not, because it's just not been done. It's allowable under the law, but it's just not something we've needed to do before. So we're working on that for you. And then there's also the quadros, which is the Qualified Domestic Relation Order for Support. These are usually associated with divorces. You do not need to get divorced in order to get one of these court orders. And you use this for things like in investment or IRAs. So, I mean, just statistically, I'm not saying just generally though, the husband has a very large IRA and it's kicking out a very substantial RMD, required minimum distribution. Like they've got to pull, $28,000 a year from it. Well, that is going to be income used for calculating their share of cost. If you get this quadro through the family court, you can allocate 100% of that to the well spouse, and now it will not go to their share of costs. So there's a lot of options that we can do depending on the type of asset you have. So if you've noticed, that's why I focus this education on financial planners, because if your financial planner works with you in advance to create the proper mechanisms by which we can, income shift, it'll be great. Well, so what about transfers? So if you Google this, it will say there's a 5-year look back. You cannot make any transfers, blah, 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 blah. Those, again, we're California. That rule applies to every other state. There is currently no transfer penalty, right? Transfer rules are in place to discourage people from intentionally impoverishing themselves to qualify for Medi-Cal. But the problem is, and I say questions remaining on transfer or gifting because the rule says that as long as you're not doing it for Medi-Cal purposes, we don't care. But their rule also says is we can't ask you if you transferred anything. So it doesn't, the law doesn't really make sense right now, but just know that there is no penalty for transferring after the law change. So sometimes what we will do is we will transfer assets around that are highly income producing, right? And then that happens, especially if you're not doing it for purposes of just qualifying for benefits. All right, I'm kind of rushing because we're running out of time, but it's important. Estate recovery protections. And I say new California law, but I'm just kind of at this point hitting my age, but January 1st, 2017.
I'm just going to interrupt you real quick. We're going to go over time no matter what you do. So don't rush. I've made an announcement to everybody in this because this is vital information for our attendees. Take your time, do what you need to do. We also have lots of questions we're going to answer at the end. We really appreciate all the time you're donating to us today. And again, for everybody who's attending who maybe has not seen those messages, this program is being recorded. It should be up on our website and coming out through our newsletter in about the next 2 weeks. We will also try to make sure that it gets out to everybody through an email that we send out in the future for all of you who attended. So if you're not able to stay past 12, thank you for attending today. And please watch the rest of the recording when we get that out. Otherwise, we encourage you to stay on, especially if you've asked questions, because I am going to make sure that Kim has a chance to answer those before the program wraps up. Thanks for giving me a second, Kim.
Okay, so the estate recovery protections, meaning that we've talked about this repeatedly, and I say it repeatedly because it's so important. I will tell you, when these laws changed, I rudely rose my hand and said, so you're telling me that rich people will be able to qualify for Medi-Cal but never have to pay for it, right? When the laws changed about who's going to pay for Medi-Cal because of these major changes, they want to get it back from estate recovery. But as I said, and I'm going to say this over and over and over, you cannot recover from a trust. And that is why it is so important. But the average person in middle class or lower income do not see lawyers and get trusts, so that is the problem. So your estate is the only thing, your probate estate is the only thing they can recover from. So what is not subject to probate? Your revocable living trust, anything you hold in joint tenancy. But please don't just hold your home in joint tenancy, because when one spouse dies, then what? Then you're set. Then when you're a grieving spouse, you have to go do a trust. So just do it in advance, right? Because you better die in the right order, and you better not one person die in the car accident and the other one have a traumatic brain injury such that they can't do it, right? You want to plan. You can do payable on death and transfer on death on your bank accounts and things. And I think that's great, except, my crystal ball is not very good. People better die in the right order, right? You better not have a horrific crisis in which your beneficiary dies before you, because now it's an estate and it has to be probated. So please make sure your beneficiaries are up to date. They have a primary, they have a contingent. That means like if people don't die in the right order, I have a backup plan. I do want you to understand though, there are exempt from recovery, which is a homestead of modest value. What does that mean? It means a home that it has to be your a home, your primary residence, that is 50% of the average median price. So the county that you're in, if your home is less than the median price, the average price, that is going to be prevented. You're not going to be able to prevent, or you're not going to have that recoverable, but you do have to prove it. And it's a little bit of a process. So now we are at question. Okay. So I'm seeing, and I see, is a boarding
Yeah.
care safe,
We
for
we have a
example?
lot actually, so bear with me because I'm gonna go back. Somebody actually asked a question that relates back to the first section of this, and I want to make sure we answer that first. So how helpful or legal is a durable financial power of attorney?
It is 100% legal and extremely helpful. The most helpful thing you're going to have. Like, you need it. If you want to access bank accounts, if you want to, do things like cancel the paper, talk to Cox Cable. Oh, good luck talking to a cable company if you're not the one on the cable bill, right? That's what a power of attorney is for. Keep in mind though, whoever you're using it with doesn't have to accept it. There's a statute in California that says they have to, but there's been a case out there, I think it was Bank of America, that said, no, I don't, because my internal policies say I don't like yours. Now, I will tell you, I'm going to throw Fidelity under the bus in particular. They have a policy that if your power of attorney doesn't allow for something specific, they will not accept it. And so that's why trusts are so important, because all financial institutions will accept the trust. But if your power of attorney isn't written in such the way that the financial institution likes it, their internal policy can say no. Now, you got to remember, financial institutions are going to follow the law in which the state they are incorporated in. So, if they're in Florida, a Florida statutory power of attorney is going to hold more weight than the California one. That's the issue you run into, which is why I don't like just having powers of attorney. It is a better option than none. Because a lot of times that financial institution will let you close the account, but they probably will not let you manage things.
Thank you. So I'm going to go back up to that top question. So you spoke a little bit about board and care earlier. Is board and care safe? For example, somebody wouldn't be able to wander out.
So that is each board and care specific. And so that's what you're going to have to talk to them specifically. I mean, I've had a client who his mom she was going to elope from anywhere, we call them elopers. There's video of her pushing things and jumping over a wall up in Hollywood, found her way to Fallbrook. Just saying, it was quite incredible. She was covered in poop. It was a horrible situation, but she was able to get in a cab. She was able to take a train, get on a bus. I mean, the whole thing. And I've had another client whose dad, I have video of it, snuck out of a very, very high end memory care facility, very gated. 3:00 in the morning, he figured out the system of when the caregivers came and go. 3:00 in the morning, was hiding in the bushes and snuck out when the caregiving shifts came through. And so there's video of that. So I don't really, if you've got a wanderer who is hell bent on getting out, they're probably getting out. But most boarding cares, if you have a wanderer, they usually have some sort of secure options, but you have to find the place that fits that person.
And for any of you who are attending today who may be dealing with wandering behaviors and need more advice, please give us a call, 492-4400. We deal with this a lot and have many recommendations, especially for great programs in San Diego that can maintain safety for someone who wanders. But also, if you're interested in looking into and understanding these different types of care facilities, we maintain lists of ones in San Diego that we can refer you to, but also we can help better go over these outlines again, because we know it's a lot of information to understand all these different types of care facilities. So feel free to give us a call if you have more in-depth questions about that, and share with us your specific situation about the person you're caring for, and maybe we can guide you and give you some advice about what level you should be looking at. So thanks for that. Let's go on to our next question. So if the senior's income is too high for Medi-Cal due to pension and Social Security payments, is there a way to voluntarily give up some income in order to qualify? I thought I read about this. My mother would like to qualify for IHSS, but her income is too high to qualify for Medi-Cal.
Okay, sorry. So I apologize because I had to get my kids, but I'm trying to find them a ride home. If it's too high for Medi-Cal, that's the problem. So you can't voluntarily give away certain types of income. And that's the issue we run into. Social Security is a guaranteed payment. Pensions are a guaranteed payment. That is where we run into trying to increase things. And that's the people that are in the hole. And I don't have an answer for them. Those are the ones that I feel are really stuck, because the skilled nursing will always accept you because it's 100% of your income, less $35. But that's where we run into the issue. So a lot of times I don't have an answer for them on the assisted living waiver program. Sometimes it does. In-home supportive services could work based on the share of cost, but that just becomes the match problem. There are options though for buying, like if you're just a little over, you can buy health insurance and other vision and dental insurances. And that, because Medi-Cal calculates your gross income less your insurance costs. So your Medicare, your supplement, your dental, your vision. So I've had people who were, bought an extra $1,000 worth of unnecessary insurance and then got coverage for Medi-Cal 100%. So even though it's like, to me, it sounds, look, I believe it's an insurance scam in some sort of way, but it's the law. So I'm sure some insurance lobbyist, paid off some senator to do it. I mean, that's just that's my negative thought on the system, but that's the way it goes. So you can buy unnecessary insurance to lower it. You lower your actual income amount in order to do it. And there are some insurance companies in town that specifically do that for a living. So.
Thank you, Amy. This is a complicated question. Again, if people need more assistance, give us a call. We might be able to guide you towards some other resources. We might be able to help look for other options if you don't qualify for Medi-Cal. I'm going to jump to another Medicare question real quick, Kim. Does Medicare or Medi-Cal help pay for hospice care?
Medicare does cover specifically hospice care. So that is something that your Medicare is phenomenal with. And yes, you should definitely if your loved one qualifies for hospice, they should be on it because you get a lot of support. More importantly, the family member gets support as well. And that's why it's so important. But you also get more oversight, some nursing care that comes in, diapers, things like that hospice will cover. So yeah.
I'm going to go back to some of these ideas about care facilities. Are the care facilities rated for consumers to see and evaluate the facilities?
Yes, you can go to the state's website for this. I don't know exactly. It's the Department of Health and Human Services, I think, is going to be the one you're looking at. But if you just kind of Google their name and rate, their rating, it will show up and then you'll see all the complaints. I like to tell people, be careful of the types of complaints. There's A, B, different types of levels. Some of them are administrative, right? So I've seen people get dinged because they had the TB test for one employee in the wrong file of another employee. So like a piece of paper went into the wrong file. That is, okay, yes, they should get dinged, but it does not say anything about the quality of care. Sometimes they'll get dinged for care related things, but it's because the water temperature was 1 degree too high. So you kind of have to look at what the complaint was, because it's good that they're being that meticulous in reviewing them, but then you also have to be mindful of, is it a real care issue, or is it like, okay, really, our hot water was 1 degree too hot and my TB test was in the person behind its file on accident? Like those have nothing to do with care. So be mindful when you're looking at those. And then also be mindful is that people like to complain, for anything. And I've noticed that a lot, where a lot of these complaints are really unfounded. You know, they, I find that you can't make some people happy, and they're going through an emotional crisis with their loved one. And so they're just going to be unhappy about anything. And so sometimes just be mindful of that.
And also, Alzheimer's San Diego does keep up on these sorts of things, and we manage our list very carefully, and we remove facilities that have a history of problematic behavior. So it's always helpful to call us and ask us about those sorts of lists, and we can share more. And again, coming back to, if you're still trying to figure out what it is that you're hoping to, like what level of care you're looking for, we can help navigate you towards that, and residences that we're monitoring in those cases. So definitely feel free to reach out around all of that. I'm going to go to a question about long-term care insurance. So can long-term care insurance companies cancel your insurance for potential discrepancies in your application regarding healthcare history?
I cannot answer that because I don't know. I need a lot more details, and I need to know exactly what was happening in that. So that's just something I can't answer.
Thank you, Kim. Appreciate that. It's always better to not answer a question than answer it if we don't have a good answer. Let's see. For the next one, related to VA assistance, I served for 42 years in the military. Can I receive vet care for my wife?
So for if the spouse is the one that becomes ill, yes, there is a spousal coverage, but it is going to be it's going to be a limited amount, but there is a long-term care benefit for the spouse. It is just limited to the basic pension value, not the aid and attendance value. So there is an option out there, but again, you still have to meet all those financial eligibility requirements. So you can't have more than that net worth value. So that would still be the problem.
And then there's another question here about VA benefits. If someone was previously married to a veteran during their time of service that meets the 90-day, 1-day criteria, is that person eligible for the spousal VA benefits?
Only if the marriage terminated because of a reason of death. You cannot, a divorced spouse is not eligible.
Helpful. Thank you.
Unless there is the one exception, unless you can prove that you were divorced because of abuse.
Yeah. In the meantime, sorry, say that again, Kimberly. I'm sorry, because I think I interrupted you.
But you have to prove it. So it's not an allegation, it's an actual proof.
Excellent. There's a question more about working with your firm, so I'm going to save that till the end when we talk about your firm in a moment. We've received some questions in the meantime while you're answering questions. Would it be an advantage to put a home into an irrevocable trust instead of a revocable one?
So that is going to be case specific, but in general, we don't do that anymore. That was the standard planning prior to the change in the law, but we don't really do that unless you're looking for VA benefits, because the home is still, you can still transfer the home under veterans benefits into irrevocable trust. The idea though is why would you now? There's a lot of negative potential consequences for purposes of capital gain step up and things like that. So if your attorney is still selling those trusts, I would ask them, how does the change in the law impact that? Because there's a lot of attorneys out there still selling these trusts that are inappropriate, in my opinion.
Another question is, does my trustee agent or the agent of my trust need a separate power of attorney?
Yes. Yes. So you're a trustee of a trust, or you're a manager of a trust, and you're an agent under a power of attorney for everything that's not a trust asset. So you want both. You need both, because not everything's going to be managed by your trust. Like anything in your individual name, your Verizon, your Cox Cable, your IRAs, things like that will never be in your trust. And so your power of attorney, you need an agent under a power of attorney and a trustee of your trust.
The next question, and again, this may be one that's better oriented back towards somebody giving us a call at Alzheimer's San Diego, but Kim, you can put in your 2 cents here if you'd like. Is a medical facility's quality of care less than a non-medical facility?
It completely depends on what you're looking at. Most medical facilities are more custodial and less, that they provide less socialization. So that's where you run into a lot of issues where you're just getting care for your needs and not your well-being. I guess that's the better way to say it. It kind of depends, and that's why it's just going to depend on what your needs are. And I got some people who they just want to sit and watch TV all day anyway, so they don't care, and it just depends.
Yeah. And again, in those kind of situations, I highly recommend that somebody give us a call, Alzheimer's San Diego, ask us about those specific details of what you're looking for, and we can help give you some guidance about what facility might be a good choice for you. Also, there's a question here about in-home caregiver IHSS essentially. So, Kim, I'm actually going to skip over this one because it gets very in depth in regards to how a family member becomes paid by IHSS. For the
Well,
person who asked this, oh yeah, no, go ahead.
actually, just I'd like to answer it. It's really quite simple, actually, because the idea is, if the person needing care qualifies for Medi-Cal, then you just get them qualified for Medi-Cal, and then you Google in IHSS San Diego. There's a 1-800 number. You call that. You get then somebody's going to come out and evaluate the hours that the person's entitled to, and then they qualify. And at that point, you fill out a form as to who's going to be paid for by the county, and then and then they get paid for they submit their hours and they get paid just as a normal employer. So it's actually it's a really simple process, but you do have to hit the threshold of qualifying for Medi-Cal first.
And I want to mention, so the name of that organization that runs that is the County of San Diego Public Authority In-Home Supportive Services, but most of us just call it IHSS. So Kim is right. If you look up San Diego County IHSS, you'll get related to the public authority website, and it'll give you more clear guidance on that. But if you're having questions or anything about that, give Alzheimer's San Diego a call, because we help people with this quite frequently, actually. But Kim is right. It frequently has to do with the Medi-Cal eligibility first and foremost before you taking those steps into the public authority system and getting a family member to be paid for IHSS. So Kim, go ahead and continue, and I'm going to ask that last question when we get a little bit further on.
Oh, okay. Oh, majority. There we go. Okay, next steps. So next steps, I need you to gather everything. What do we do, right? We gather everything. We're looking at what we have, copies of everything in one location. As I said, let the person know. The trusted family member needs to know where that is. The friend. How do we find it in a crisis? Where is it going to be? It doesn't do you any good to have these documents that nobody can find. I need you to update them. I really need you to discuss the contents with them so people understand what they want, because things are going to change. Life is going to happen. And then you need to find out if we can do something on file now. So before you start losing capacity, can I get my power of attorney approved by the company that I want them to acknowledge it? I'm leery of that only because circumstances change, but sometimes you just want to know what it is. If you're outside of California, please find an attorney that's licensed in the state you're going to be in. Right, I just went through an entire plethora of things in California that we can do. You cannot do those in other states. And that means that if you ever intend to move, what we do here, you will not apply in Arizona, will not apply in Maryland. So it's really important that we really are mindful of the long-term care plan. We implemented a really good plan for somebody, and then she decided she wanted to move with her son in Virginia, and all of it was for nothing. So be very mindful of the plan, and that what you put in place now won't transfer unless you consider it. So the resources, right? There's a lot out there. So you can get an advanced healthcare directive on the California Office of the Attorney General's website. Physician's orders for life-sustaining treatment, read about them. The Coalition for Compassionate Care of California has a lot of information on this, but remember, it's an order. So be mindful that it is in place and it is an order. There's also a lot of consumer toolkits, and then a lot of provisions specifically for dementia if you go to Compassionate Choices. Legal resources. So I'm a member of NALA, National Academy of Elder Law Attorneys. That is a great organization. So NELF is National Elder Law Foundation. They are the organization that governs my certification. Just because I have a certification doesn't make me fancier than other elder law attorneys. It means I passed an exam. But NALA, a member of NALA, will attend all the regular educational things. And that's important, right? Because what we do is really hard and there's no manual. People are like, let me have the book. There is no book. That's why estate planners don't do what I do and what a lot of elder law attorneys do, is because there's no book on it. You have to invest the time at places like NALA. You can always go to the state bar website. You want to check if you're hiring an attorney, please check, see if they have any issues with their license. The San Diego County Bar Association is a great place to also kind of find lawyers. But CANNR, California Advocates for Nursing Home Reform, everything I talked about today is in much more depth at cannr.org. when you're Googling stuff, you're going to 95% of the time come up with national information that doesn't apply to California. Canner is the only place that I know of that has a comprehensive information of just California specific information. When you're looking at regulatory agencies, this is, somebody had asked about how we check licensing. This is a good place to go, right? These are the three places you're going to go look at for any types of complaints or issues, or filing a complaint. Medicare.gov is a great place. I will tell you a secret about how I learned about Medicare advocacy. I went to medicareadvocacy.org because a client came in for something I had no idea about, patient dumping. I didn't know how to appeal things, and it has everything. It has these amazing self-help things I learned, and I didn't know what I was doing. And I called the 1-800 number and they walked me through it. And now I teach lawyers how to do it when all I did was go to medicareadvocacy.org. So these are amazing options. Social Security Administration is difficult to deal with, but they have a lot of information. The compassionate allowances I talked about, so there's how to find it. Medi-Cal's website, it has everything there. It's a really hard website to navigate, I'm not gonna lie. And then if you are a veteran, please just spend some time going through the Caregiver Support Program website to see what's available for you. This is me. And then I think we have one last question.
Yeah, so actually, Kim, if you don't mind back at one quick slide, go back to yourself here. So their question was, I have a relationship with an estate planning firm that also provides trust administration as well when needed. Your firm may have additional insights specific to dementia that could be beneficial to us as well. So could you do or coordinate with other attorneys in such a case for appropriate compensation?
I do. I will consult with other attorneys all the time. Actually, majority of my business is just from other attorneys who are not comfortable with dealing with the level of what happens when people get sick, right? The implementation of the plan. So I definitely consult with attorneys all the time. Sometimes it's real simple, so there's no charge. Other times it's an hourly charge, and I charge $4.50 an hour.